Supreme Court heard oral arguments from both parties last week. And Stephen, I'm curious, what was your take in listening to oral arguments? What did they reveal to you about the merits of the case and how the Supreme Court might rule?
Well, Tori, I think all nine justices, the Moore's lawyers, and the government's lawyers all shared a perspective: don't mess with taxes. The government laid out how a bad decision, or at least a wide-reaching decision in Moore, could yet preempt our business taxes, investment taxes, loopholes could be opened, trillions of dollars could be lost. The Supreme Court justices received that message and sent it back to both the Moore's lawyers and the government's lawyers. How can we make a decision in this case without blowing up the tax code, like Speaker Ryan warned about? And so, listening to the arguments last week, my takeaway is that all the parties are looking for a narrow way to decide this case without blowing up the tax code. Having said, though, the reason the case, in my view, got to the court was that there was an interest by a lot of conservatives to tying up Congress's hands on taxing capital, especially future taxes on billionaires. And the question to me is, will the conservatives get the kind of opinion they want if the Supreme Court rules too narrowly, that the Moores either win or lose their $15,000? No one really cares. The question is, will the court use the Moores case as a vehicle to tie up Congress on capital taxes? If they do, I don't see how they can limit the reach and the damage to our code.
Before going to Steve Robinson, I can't resist a follow-up question there. I used to work at an appellate court. I was a law clerk and later chief staff attorney. And the use of footnotes and concurring opinions is fascinating. And I'm wondering, when you say that, if they do decide, well, let's take a very narrow view here and not get a justice or a couple of justices could take the opportunity to write a concurring opinion saying, now, this doesn't mean that a wealth tax, if they approve the MRT, they could put in some language saying, writing about applicability or non-applicability to a future wealth tax, if that's what they wanted to talk about. Do you think there's some possibility that could happen?
Bob, I think yes, that will be where the play is. I expect all nine justices actually to be on the same side, ruling against the Moores, that the Moores' complaint about being taxed on earnings that had not been distributed, I think that will be readily dismissed. I don't think there's much of an argument there. And the question then arises, on what basis will they be dismissed? And will the court signal, well, maybe the Moores lose, but future taxes on unreceived income, like some of the billionaire tax proposals that are out there, those are suspect. Now, mind you, the conservatives and the Moores, who are carrying the water for the conservatives, already scored a big victory. They already won a major concession. The government's lawyer at the argument conceded that a wealth tax, that is a tax on property, is a direct tax that must be apportioned. And apportionment requires that the tax is collected evenly from each state, which practically is impossible. Like if you wanted to collect a billionaire tax, you might not find any billionaires in Alabama to collect the taxes from. And so the government standing up there already made that concession. In my view, they threw Elizabeth Warren's wealth tax under the bus. And so at argument, I think wealth taxes have been already set back. But the government's argument really was, this case is not about wealth taxes. We can make a concession here because we really don't want you to damage our tax code by imposing a new restriction on Congress in terms of its ability to lay and collect taxes on our behalf.